Good morning, everyone. So welcome all of you joining the public presentation hosted by the Occupational Health Center. Today's the topic is about overview of workers' compensation. We are so pleased to have Michelle Hegg, a worker advisor, the worker advisor office in Brandon office, and from the Department of Labor, Consumer Protection, and Government Services. We would like to begin by acknowledging that we are on Treaty 1 territories, the traditional territory of the Anishinaabe, Greek, OG Greek, Dakota Sedinese people, and the homelands of Métis Nation. We respect the treaties that we were made on these territories, and we acknowledge that we are all treaty people here at the Occupational Health Center. We commit ourselves to a process of reconciliation with indigenous community. For the audience participation, we all know that this is a webinar format. You have no option to put your microphone on, and also you have been muted and no videos. You could just only see the presenter. So please put your comment in the chat on the chat section, and then the presenter will try to answer it after the presentation at the Q&A. Since we have a large group of audience here, so we may not able to answer all the questions at the Q&A, please contact with us afterwards to follow up. And this section is also being recorded for viewing later and share on the social media. Occupational Health Center is the community health center funded by the Winnipeg Regional Health Authorities, and we provide the services to the Manitoba workers with work-related health issues and work closely with John's Workplace Health and Safety Committee for training and resources. So our services is free. Please visit our website for more information. And so now this is the time. Please join me to welcome Michelle. I'm going to stop sharing now.
Thank you, Tiffany. And I want to thank everyone for taking time today to come and listen to me speak about the overview of workers' compensation. Let me just start my slideshow here. Okay, sorry for the technical difficulties there. I'm definitely not a Zoom expert. I usually use Microsoft Teams for a lot of our presentations. So today what I'm going to be going over for you is an overview of workers' compensation. And this slideshow has kind of been, or my speaking notes have kind of been modified in order to modify this so that all of you, my understanding is, may be working as worker advocates, helping injured workers with WCB claims, reporting, and possibly appeals. So what I've done is I've taken our regular presentation, modified my speaking notes, just to add in some additional information from the WCB resource guide for worker advocates that has been done by the MFL. They've redid this and it's a great resource. We actually use it as well in our office for training new staff and that type of thing. And it was redone in January of 2022, so just in this year. So what I will be doing is I will be going over an overview of workers' compensation, giving you some tips as advocates out of the guide, going over accidents, injuries, reporting, types of benefits, and appeals. So out of the advocates guide, the workers' compensation system is complex, and the process for reporting injuries and making WCB claims or filing appeals can be challenging and sometimes overwhelming for workers to navigate on their own, resulting in added stress for workers who are already dealing with hardships of a workplace injury or illness, and they're already, of course, ill. The Manitoba Federation of Labor's WCB Resource Guide on Workers' Compensation is intended to assist union activists acting as worker advocates to provide support and assistance to members who have suffered a workplace injury or illness and required to help in navigating the WCB system so that they can get help they need and are entitled to. The workers' compensation system is set up as a no-fault insurance for workers who are injured at the workplace. No fault meaning a lot of the workers will get bent up on the employer didn't do something properly with regard to safety, possibly, that might be their intention, and or the employer might think that the worker was not working safely. That is under the responsibility of workplace safety and health. That's a separate government organization. As far as whether the worker gets compensation or not, that's not really terribly relevant in the adjudication process. So the Workers' Compensation Act is the legislation that governs WCB. It defines the parameters in terms of coverage, benefits, rights and responsibilities of both the worker and the board and the employer. And it talks about the appeal process. So there's the Act and regulations, which are the actual legislative documents that are covered. But the WCB also has a bunch of policies that it has, the board of directors at the WCB has come up with. All of that is available on the WCB website. So that's where you're going to want to go to get information on all of these things. They also have other things like admin guidelines as part of the policy. And there are actually something called WCB healthcare position statements on specific injuries like concussions and those types of things. And if you can get access to those, that would help you as an advocate. 75% of workers, give or take, are covered within the province of Manitoba under workers' compensation. According to the WCB 2020 annual report, there were 38,073 registered employers providing WCB coverage. So the Act talks about the generalities of the system and gives WCB the authority to write their own policies on certain things and define how the Act applies to specific circumstances. This is all covered in the MFL guide in the chapter 3. The one thing, as far as if you are going through the Act and advocating for a worker, be very cognizant of language that's actually used. And what I mean by that is, in places in the Act, it'll talk about the WCB shall, and other places, the WCB may. If it is a shall, that's mandatory language, and the WCB has to do that for a worker. Just be cognizant of that, just as a tip. Okay, in the WCB Act, it actually defines an accident. So under section 1.1 of the Act, an accident includes a chance event occasioned by a physical or natural cause, a willful and intentional act that is not the act of the worker, or an event or condition or a combination of events or conditions related to the worker's workplace that results in a personal injury to a worker, including an occupational disease, post-traumatic stress disorder, or an acute reaction to a traumatic event. That is one paragraph that has a lot of information in it. So just for an example, a chance event occasioned by a physical or natural cause. That would be one of the, let's say a worker was climbing a ladder, gust of wind, he fell off the ladder. That's a chance event by a physical or a natural cause. A willful and intentional act that is not the act of a worker, as far as an example, I can think of a convenience store worker who was robbed. That's a willful and intentional act on the part of the robber, but it is not an act of the worker. So if that robber were to injure the worker, that would still be a WCB claim. C actually refers to an event or a condition or a combination related to the worker's work or workplace. So once we start to get into that part of the definition of the accident, you're talking about like maybe a repetitive strain injury, carpal tunnel syndrome maybe, or possibly an occupational disease, like let's say a firefighter that is exposed on a regular basis to carcinogens and in the smoke and things in the course of his work. So that talks about the actual event that led to the, but the big thing is it also had to have resulted in an injury to a worker, an occupational disease, or a psychological injury such as post-traumatic stress disorder, or an acute reaction to a traumatic event, such as that convenience store worker I talked about that may have a psychological injury or a fear of returning to the workplace that is actually an injury as well. So we talk about the different types of injuries that a worker may have. Now, between the Act and the policies, our office and the MFL, there's different names for them, but they're basically three types. I've kind of gone into those with the definition of the accident. But under A, we have traumatic injuries, also sometimes called acute injuries. And in the MFL guide, it is called a single event injury is what they call it. So examples of those, you're going to have a clear cause and effect event resulting in a psychological or a physical injury to the worker. A bone break, falling from a ladder. You're going to puncture or tear or something on the body because of sharp machinery, or a worker gets a concussion after a fall or a blow to the head. So that would be the traumatic injuries. Those are the easiest to identify, the easiest to adjudicate, and less likely to have appeals on those because it's a specific event at a specific time. There's not a lot to dispute. Then there's the non-specific accidents, also sometimes called cumulative injuries or repetitive stress injuries, or in the MFL guide, it's called multiple event injuries. They are those which develop over a period of time and are usually due to repetitive movements required in a specific job. Often these injuries develop over the course of months or years doing the same type of movement involving force or impact on that movement on the body, sometimes referred to as repetitive strain injuries. Examples that they've got: hip dysplasia due to welding in a confined space, shoulder bursitis from swinging a hammer, a back or hip injury due to repeatedly lifting heavy objects. Other examples could be carpal tunnel syndrome, lateral epicondylitis, or tennis elbow. Those are types of cumulative injuries. More likely to be appealed or harder to adjudicate because there was not one specific, we can't say that on June the 5th this happened, right? It's over a period of time, so it's a little harder to adjudicate. Then there's occupational diseases. Illnesses arising from workplace exposure to harmful chemicals, toxic substances such as carcinogens, asbestos, lead, or noise that can result in cancers, poisoning, deafness, and other serious and sometimes fatal conditions. So we've got things like hearing loss, cancers, especially in firefighters and people that are exposed to these things, asbestosis or mesothelioma. There's also radiation poisoning. Those are all things that would be considered an occupational disease. Occupational diseases are sometimes harder to adjudicate, again, because it's over a period of time. And for instance, let's say hearing loss, they may be exposed to lots of loud noise in the workplace, but they also go hunting every year and shoot multiple firearms, or shoot firearms maybe as a hobby. And so then as far as occupational diseases, the WCB is left to try and prove, or we're left to try and prove after they've denied, that it was the predominant cause of their hearing loss or any other occupational disease that they have. Workers and advocates should also be aware of three types of diseases that the WCB will not accept. If they think it is a disease of ordinary life, arthritis being one of them, it can commonly be acquired from a variety of life situations. It will not be considered an occupational disease unless the risk of contracting the disease through employment can be shown to be greater than the risk of ordinary life experiences. The other thing, and that's why we have stress listed here, the WCB will not accept ordinary stress as an occupational disease. The only exception is an acute reaction to a traumatic event. Traumatic event, of course, being, if you're a paramedic and you're witnessing, serious injuries, firefighter having to cut somebody out, people passing away, robberies. It has to be a big event. It's got to be something clearly discrete enough that changes the psychological condition from before the worker experienced that traumatic event. If it is the ordinary stress at a workplace, such as promotion, discipline, transfers, demotions, layoffs, termination, a worker can still experience psychological injury from that, but the WCB will not accept that as compensable. So let's move on to reporting an injury. First thing is that the worker needs to make a written report to the employer. And also in here, we also say union, because some unions definitely want that information as well. It is covered in Chapter 4 of the MFL Guide. And technically, a worker has 30 days to report it to an employer, unless, of course, you have a union contract that says differently. We always recommend to immediately or as soon as possible report that to the employer. Also seek medical attention with your own doctor at a walk-in clinic, if necessary, at a hospital and ER also if necessary, and we say as soon as possible as well. And notify WCB of the accident. You can report online, you can give them a call, and technically they have 1 year, but again, we do not recommend any delays in reporting. And the reason for that is delays in reporting or seeking medical attention make it more difficult to establish the workplace injury or the details of that workplace injury. Memory gets worse over time. And we see a lot of claims where they just say, well, you took, 3 weeks to go to get medical attention. Now we can't say that injury relates to that particular incident at work. And so that's where a lot of our appeals come from. So we've got on here a notice of injury to the employer, one of the forms that can be found at the WCB, and some tips regarding what maybe to tell injured workers if you're advocating for them. So you want to discourage workers from being overly technical in explaining what hurts or trying to use language that they think a doctor would use. Oh, I think I've got carpal tunnel. Well, it might not be carpal tunnel, and that might be kind of used against them later, used against the worker, because the WCB could say, well, they thought it was carpal tunnel. Turns out you had something wrong with a ligament, something else like that. And so it leads to actually extra adjudication later. Or the worker could end up getting too precise, thinking it's carpal tunnel, but not saying, that it also hurts up into the hand and up the elbow. And that leaves out very important details. Do not attempt to self-diagnose the injury, even if it feels like a recurrence of a previous older injury that they had at work. Workers should only describe what hurts, not the inner workings of why it hurts. That's up to the doctor. Describe how the injury happened in detail, not only to the employer, not only to the WCB, but also to your doctor, so that the doctor gets the medical, the mechanism of injury properly on the medical forms. In the case of a repetitive strain or a cumulative or multiple event injury, describe the normal actions the worker carries out day to day, like the kind of machinery or tools used, what the workstation consists of, if they stand, if they sit, whether they're monitored, if they're on a piece rate or quota system, how fast, how long they do the job without a break, the weight of the material or the tools that they're using, the amount of repetition, hazards, environmental conditions, changes in work tools, volume of work, conditions, work processes, or shifts, especially if there's been, short staff. This situation happens all the time. So then the workers that are left are left holding the bag and have to do things faster, quicker, that type of thing. If possible, we always recommend trying to get a picture of the workstation that is being used. All accidents that result in an injury to the worker must be reported to the WCB, and especially if they need medical attention. So after a worker puts in a claim, then the WCB has to adjudicate the claim before it can be accepted. For additional information on the adjudication of claims, the MFL guide under Chapter 5 talks about adjudication. So here is where the WCB gets their information from. They look at the worker accident report and the employer accident reports. They look at witness statements. They look at the medical reports and the description of the accident, or otherwise called mechanism of injury, or MOI, sometimes you will see in a file. So what did they do? They're going to compare the dates, the times. Has the worker provided the same mechanism of injury to the doctor and to the employer, etc.? Is the description of the injury the same to the different people involved? Is the diagnosis consistent with the type of injury? Also, if they had any prior problems to the area of injury. They're going to look at the specifics of the accident. Okay, so what was the worker doing when they were injured? Are we looking at a specific or a traumatic cause, or are we looking at a gradual onset? Was the worker actually engaging in work activities at the time of the accident, especially if it was a traumatic injury? If they were goofing off in the lunchroom on their lunch break, jumping, standing up on chairs, dancing, whatever, that might not be accepted. So are they engaging in their work tasks? Where did the accident take place? Was it at the workplace? Was it off work premises? Was it in a vehicle? Was it on the way to work? Was it from work? Was it in the parking lot? There are a lot of policies, a whole bunch of policies indicating where and when the WCB will accept the accident taking place. And when did it occur? Was it during the work shift? Was it at lunchtime? Was it during a break? So when did the accident occur? So they'll be using all of that information to determine whether or not it meets the act. And definitely look in the MFL guide, because they've got a lot of information in there on it, but definitely the WCB website with all of their policies is something really important that you want to watch too if you're going to be advocating for a worker. Pre-existing conditions, that's where we were talking about, did they have anything wrong with that area before the accident? So WCB does have a policy on pre-existing conditions. If you need to know which one it is, it's actually policy 44.10.20.10. Can be found on the WCB's website. In general, a pre-existing condition is a relevant health condition that was present prior to the workplace injury. A pre-existing condition may or may not be symptomatic and may or may not even be known to the worker before the accident. Sometimes pre-existing conditions are discovered through medical investigations done by healthcare professionals in relation to a workplace injury. According to the WCB's policy on pre-existing conditions, the WCB may provide compensation or benefits when a workplace accident worsens a pre-existing condition. And sometimes the actual injury itself ends up being a combination of both the pre-existing condition and the injury. As far as an example of that, let's take a knee injury. So if the worker had some arthritis in the knee prior to, and didn't even know it, it wasn't hurting him, he had no idea it was there. The only way to find out at that point, because it's so early in the process of the arthritis, would have been to get an MRI or something similar. But because they've had a workplace injury, possibly torn a meniscus or something in the knee, they are getting an MRI, and that's when they find out that the knee was already a bit compromised with the arthritis. If it's found out that the injury was a combination and that the pre-existing condition played a part, but not the whole part, the WCB is responsible for the total injurious effect of the injury or the workplace accident. They use a couple of different terms at WCB. There's aggravation and enhancement. And basically an aggravation is the temporary clinical effect of a compensable accident on a pre-existing condition, such that the pre-existing condition will eventually return to its pre-accident state unaffected by the compensable accident. That's the lucky ones. Workers who have an enhancement, that's where the compensable injury permanently and adversely affects the pre-existing condition or makes necessary surgery on a pre-existing condition. An example of that I can think of would be if you had some degeneration or arthritis in the spine. Maybe you had a bit of a bulging disc beforehand and you suffer a back injury. Well, as a result of the back injury, that disc that was only partially bulging is now completely sequestered. It's completely ruptured and now you need to have surgery. That would be an enhancement, the permanent worsening as a result. There is actually also a third that we don't kind of list here because it's a little more rare and a little harder to prove, and that would be acceleration. So that would be speeding up the process of a pre-existing condition, usually arthritis. If you have arthritis in your knee, let's say normally it takes 10 to 20 years before it starts to become symptomatic for you. But after a surgery, you really see the degeneration of the knee speeding up. Hard to get any kind of proof from doctors that that's what's actually occurring, but that is something that we do sometimes appeal. In certain instances, the WCB may deny the workplace cause of an injury by arguing that the injury did not result from the accident, but was simply a coincidence that the pre-existing condition just started to become symptomatic at that time. Also, in some cases, a pre-existing condition may delay recovery from a workplace injury. So if you have a knee strain, let's say, and they say normally workers are back to work in 6 to 8 weeks, normal recovery time. Well, maybe if you have arthritis in the knee, that might look more like 12 weeks. So the WCB might end the worker's entitlement to benefits based on the expected time frame for recovery, and it could be argued the worker is entitled to further benefits because the recovery has been prolonged because of the pre-existing condition. The other thing that can happen in a file is that a worker could have a recurrence. So a recurrence, or sometimes called a relapse, refers to injured workers who appear to have recovered from their workplace injury, but upon returning to work, and possibly upon returning to regular duties, experience a worsening of the original injury or illness. That can be seen a lot of times with a sprain or a strain type injury. So the worker is responsible for promptly reporting this relapse or recurrence or potential relapse or recurrence to the employer, to the WCB, and to their attending physician. WCB is responsible to determine if it's related to a new injury at work or related to the workplace at all, or if it's an actual recurrence. So what can happen is the worker can return to regular duties and then pick up something, experience a pull on the affected limb or whatever, and that might actually be considered a new injury. Now, there is a policy, 4410-2050-10, recurring effects of injuries and illnesses. But what that mostly speaks of, not just the recurrence and whether it should be a new accident or not, is because if it's a new accident, they may have to recalculate the benefit rate for the wage loss in that. So if the injury does heal and there's a flare-up, they have to determine whether it's a new accident, and it would be fully compensable if it's work-related. Moving on to the different types of benefits. So some of the different types of benefits, and the most used ones, of course, the big thing is the wage loss benefits. Workers who cannot attend work are compensated for their lost wages. The rate is about 90% of the net, and sometimes 100% of the net if the worker is actually making minimum wage. And it's usually based on the average earnings in the year or sometimes the 2 years prior. Now, there's different, more rare wage loss calculations, and like literally we could spend a half day here talking about how they calculate wage loss benefits, but it is all listed on the different policies that they have. Medical benefits, which could include doctor's appointments, surgeries, physiotherapy, chiropractic treatments, prescriptions, diagnostics, imaging, hospitals visits, braces, canes, crutches, that would be all considered different things in medical aid that would be paid for from the worker. Independent living allowance is something that would happen if the worker suffers a severe injury. Usually examples are like amputation, spinal cord injury, and it would cover such things as home modifications. Maybe a wheelchair ramp is needed to get the worker into the home, sometimes expanding doorways or modifying the bathroom so that the worker can get in and out of the bathtub. Also things such as lawn care or snow removal are sometimes listed under independent living allowances, as well as sometimes home care workers to come in like after a surgery or something to assist the worker. The worker might also be entitled to travel expenses. So if the worker normally travels, let's say 20 kilometers to work, but they have to go to Health Sciences Center and that's 100 kilometers from where they live, they may be reimbursed for the 80 kilometers of travel. That would be more than they would have paid if they were going to work. There's also something called vocational rehabilitation. Vocational rehabilitation is for workers who have been injured permanently, such that they can't return to the occupation in which they were working before. And there's an entire hierarchy once you get into the vocational rehabilitation policies. It offers retraining, job search, possibly courses, incidentals such as, you know, computers, textbooks, that type of thing, possibly, to get the worker retrained and into a new job. There's also something called a permanent impairment award. That is with permanent injuries as well. And it calculates decreased range of motion in a joint, decreased sensation or scarring for a worker. Now, it's never as much as the worker is going to expect, never calculated until the worker has reached maximum medical improvement, and then they realize that they're going to be permanently impaired. There's no compensation for pain and suffering or loss of quality of life. It's just a numerical award. There are some other benefits that aren't kind of talked about here, things such as fatality, those types of benefits. That is listed in the different policies if you want to go through. I've just listed the most used benefits. Now, sometimes if a worker is turned down for WCB and is in the process of appealing, it sometimes can take a while for the worker to get access to wage loss benefits if they've been denied and still can't return to work and they're in the process of appealing. So there are other sources of benefits that the worker can turn to, such as sick leave credits, employment insurance, short or long-term disability. And sometimes the worker might want to discuss with you those types of things, or you might advise them to maybe search out those types of things while they're appealing their denial of benefits. The big thing that you want to know is that WCB benefits are non-taxable. So a lot of times, I mean, and the workers should be getting their own financial advice. It's always better to try and appeal the decision and you know, on the WCB, because also then the medical aid for the workplace injury would also be covered, all of those medical things. But what would happen if they were getting sick leave or EI or disability, if their appeal were granted, then normally what happens is the worker is responsible to just repay those benefits to the disability provider or employment insurance. Mitigation. Mitigation is one of the policies, and some of that is covered in Chapter 11 of the MFL Guide. And the definition is to reduce, moderate, or lessen the severity of something, or in this case, the injury. So the worker's responsibilities include assisting in their own recovery and refraining from actions that will slow recovery and communicating with the WCB doctor and employer about any problems. So the big example, of course, is the return to work on modified or alternate duties. So let's give an example of a construction worker with a knee injury who is offered to work in the office setting, sitting at a desk, able to elevate his knee, so it's within his medical restrictions. His doctor's okay with that. But he has to pick up the phone and call the irate clients that have made complaints. And he doesn't want to do that. You know, he's a carpenter. He doesn't want to do this office work. If he refuses, the consequences of not mitigating would be suspension or reduction of benefits. Let's say they said that the worker could do this office work for 3 hours a day. The WCB might reduce his benefits if he refuses to do it by those 3 hours a day that he would have been at work. So the big thing about assisting in recovery is you have to cooperate with the treatment recommended by your doctor. So you don't refuse medical treatment. You also refrain from actions that will slow recovery, such as getting unauthorized medical treatment with, like, let's say, a natural healthcare provider, or maybe something that the WCB doesn't think you should be doing. Also, if you fail to cooperate or attend a vocational rehabilitation plan that the WCB is implementing because you don't want to do that training, or you don't want to do the job that they decided that you should, that can cause you to have suspension or reduction of benefits. Now I'm going to move on to the appeal process. In the appeal process, there's actually 2 levels of internal review. Your first level of internal review is you could ask your case manager or adjudicator to reconsider their decision to deny benefits. You may have new information you want to submit to them, or information that it would appear by the letter that they have and the reasons that they're outlining for their decision, that they didn't consider this information. So you can go to the case manager. It's usually fairly quick, and they will usually fairly quickly decide whether they're going to reconsider or not. If they don't, your next level of internal review or internal appeal through the WCB is the review office. The review office consists of senior case managers that sort of do a quality assurance review of the file and determine whether or not the first decision was accurate. A lot of times the review office might send it back to the case manager and say you failed to investigate this portion. So it could get bumped back to case management even if you do go out to the review office. If you're unsuccessful at the review office, then the appeal process moves external to the appeal commission. And the appeal commission is independent. It's not WCB workers there. And it is the final level of appeal. So we always recommend that before a worker goes to the appeal commission, that they make sure they have every bit of information that they can possibly get in regard, or especially like medical support letters from their doctor and things, to get all of that in a row before you go, because there isn't a do-over at the appeal commission. There are some very, very rare exceptions where the board of directors thinks that the appeal commission has erred in law, and or very, very rare exceptions where some earth-shattering new medical might come available later. And very rare, I think I've maybe seen it twice in 4 or 5 years. So that kind of gives you an idea of how rare it might be. So what happens when it actually moves into an appeal? So the case management level is just an internal reconsideration, but once you go to the review office, that's an actual level of appeal, and the injured worker should be aware that their employer will be allowed to participate in the appeal. And what will happen is the worker will get a copy of their full file. And the worker then has two options. They can just sign and say, yes, my employer can have a copy of my file. Or before doing so, the worker can go through every page of that file to make sure there's nothing they object to the employer having. Now, if it turns out that it's, they object to the worker having the whole file or the employer having the whole file, the worker doesn't have much leg to stand on if they want to appeal, because the employer has the right to participate in that appeal. But what can sometimes happen is that the doctor might send chart notes. Now, you've gone in to see your doctor about your knee injury that you had at work. And while you're there, you start discussing a separate medical issue unrelated to the injury. Things such as infections that you might have, your seasonal allergies, trouble you're having with children or your spouse, any number of other medical things you might talk to your attending physician about. And sometimes inadvertently, that information can end up on your WCB file. So the worker could then object to the WCB releasing this non-relevant information to the employer, and there's an entire process for that. Now, when you go to appeal, the worker has basically two options at the appeal commission, because the appeal commission is a little bit different. They can either have the appeal commission, which is going to consist of 3 commissioners who have to jointly determine the outcome of the appeal, whether the claim is allowed or whatever the issue is under appeal. So it can be done either as a written file review, which is something we normally don't recommend unless it's a very specific kind of number-based decision, or they can have an oral hearing. And an oral hearing allows the worker to actually talk to the 3 commissioners making the decision. Even now, because of COVID, oral hearings can be in person at the Appeal Commission on St. Mary's Road or via video or teleconference. And if you want more information on the appeal process, which is, there's a lot of information out there on that, you would be looking at the MFL guide, chapters 10, 11, 12, and 13 on hearing processes, writing an appeal, and the different things that may happen under the appeal. Other WCB processes. WCB also has a fair practices office that investigates concerns by employers, workers, and the general public on actions taken by the WCB. Normally, one of the big things that the Fair Practice Office deals with is files that appear to be delayed, taking a long time to make a decision on, or taking a long time to get through the appeals. Other things might be the practice of a specific case manager, those types of things. The Fair Practices Office doesn't just accumulates these things and tries to help the workers, but they don't really have any sort of authority to force the WCB to do anything. They are there just to investigate the concerns and to report to the board of directors. There's also something called a medical review panel, and it's only relevant prior to an appeal commission decision. The function is to resolve a difference in medical opinion between the workers treating doctors and a WCB medical advisor. The medical advisors are doctors that the WCB has on staff. Very, very rare for a medical review panel to actually take place. It takes a very long time, sometimes in the we've got one that has taken years. And what would happen is 3 specialists would examine the worker's records and examine the worker, usually, to come to a final decision on what the diagnosis is as a result of the workplace injury. If you are advocating for injured workers, It's always helpful to have resources available just in case those workers are denied and awaiting an appeal. So examples that you may have, and that would be from whatever area in the province that you might be located, different options for financial support, again, like the long-term disability, employment insurance, employment and income assistance, employment resources or counseling, such as clinic, crisis lines. And we've got crisis intervention. This worker distress line that we've got here, that phone number is a WCB phone number. There should be a 204 in front of that. Where WCB, if they do have workers on claim, they actually have a crisis number that you can call to get them help. Other things such as food hampers, such as, Winnipeg Harvest, or out here in Brandon, Samaritan House has a food hamper program. Things like that might be helpful to have a list available to you just in case. So the second thing I was going to cover today is just my office, the Worker Advisor Office. So what does our office do? Our office, we are not WCB. We are employed by the government of Manitoba to assist workers who disagree with the decision by the WCB or have general questions about workers' compensation. We were actually established in 1982 and incorporated actually into the Act in 1987. And we provide independent, free, confidential, private advice and services to injured workers. But those would be to injured workers that don't have other representation. So if the worker decides to get a lawyer, or if their union intends to represent them through appeals, then we would give them advice maybe, but we don't provide actual services. What does the Worker Advisor Office do? We provide three distinct services. The first being advice. Advice would be of a general nature. We're not reviewing anyone's file. We're not getting into the medical on file. We're just giving basic general advice about workers' compensation and filing a claim for benefits. If they need help in the internal review process, we provide assistance. So what that would look like is they write their appeal. We might review it for them and give them suggestions, such as maybe you need more detail when you're describing this part of the injury. Maybe you need more support from your attending physician that your injury is this, or it was caused by the actual mechanism of injury. When a worker actually moves through to the appeal commission level, we provide either assistance or representation. So the difference, assistance is the worker is doing their own appeal, and we're doing the same thing that I just listed, giving them advice on what to say, giving them advice on the process of appealing at appearing at an oral hearing in front of the commissioners at the Appeal Commission. And in some limited cases, we can offer representation. Representation is limited to the workers that the argument on their file is actually a legislative-based argument. If it works down to the fact that we're going to be making an argument that says, under Section 1.1 of the Workers' Compensation Act, here are the details that we think that the WCB failed to recognize or failed to put sufficient weight on, etc. Because most workers don't have that intricate level of knowledge of the Workers' Compensation Act to be able to represent themselves. If it works out that it's just a case that the worker needs to more fully explain the details of the accident, it's more credible if they do that themselves, and they can usually do that with assistance. If it's a legal argument, we offer representation. So what's the process through our office? First, they meet or talk to our intake department, who gets a file started for them, gets a copy of their file, and then they do what they call triage, which is a review of the file and provides assistance to the review office. If they've already been to the review office and denied, if it looks like that the worker needs either advice or representation, it gets assigned to a worker advisor, which is our level. There's 4 of us working for the government in this role, and we may represent them all the way through to the Appeal Commission. So then we review the file, and sometimes there's no basis to provide representation. In other words, we will be offering them assistance because it's simply a case that they have to better explain the series of events, what happened in the accident, possibly why there was a delay, that type of thing. If we are going to represent them, the files either fall into further file development is required, or it's ready to go with the existing evidence. It's rarely ready to go with the existing evidence in my experience. Normally, we require further file development, and things that we would do for further file development is possibly talk to their physicians, write to their physicians to get more detailed, specific support for them, or to get possibly witness statements, that type of thing, to make sure, again, because the Appeal Commission is the final level of appeal, you want to make sure that you have all of the evidence ready to go. So when we're doing appeals, sometimes we do an informal reconsideration, because sometimes we get the file and we can call the review office and say, hey, I read your decision. I don't agree with it. And I don't agree with it because you failed to take this particular bunch of information into consideration. Sometimes that works, usually not. Or we do a formal to the either decision maker, the review office, or the Appeal Commission. A lot of the reasons why we ask for reconsiderations or take them to appeal is relevant info has not been addressed. You know, the case manager forgot to call a witness for a statement, or there was a misapplication of policy or legislation, or in fact, there was medical pending. They cut them off, but they had an MRI scheduled, and now the MRI has come in and it's showing new information. Oh, and sometimes it's just follow up. Sometimes appeals or decisions are taking way too long. So now after we've appealed, what happens with the successful appeals? We usually close the file. If it's an unsuccessful appeal, like at the review office or something, we review the reasons. We assess if we can provide further representation or assistance, and we may continue representation at the next level. Representation at the Appeal Commission, the worker usually appears in person or by video or telephone and gives evidence to the appeal panel. So what our worker advisor office does if we're representing somebody is we actually submit the application to appeal. We prepare the worker for the hearing. We present the arguments on behalf of the worker. Even though the worker is with us, we do the majority of the talking. And when the decision comes in from the Appeal Commission, we explain that to the worker and then closes the file on that issue, whether we win or lose, because after the Appeal Commission, that's the final level of appeal. How long does it take for a file to get through the worker advisor office? Usually within 4 weeks, the intake department has done their review and provided assistance to the review office, or if it's complex, even if it's at review office, they may send it to a worker advisor. A worker advisor normally has their file review done within 1 to 3 weeks to determine if we can represent or what needs to be done. But the actual time it takes in the appeal process varies. It depends on the individual aspects of the file, how many doctors we may have to write to before we get the information, how long it takes those doctors to get us information back, and possibly how long the wait time is to actually get a date for the hearing at the Appeal Commission. At the Worker Advisor Office, we have intake officers that start the process for you and do help you through the review office usually. We have worker advisors, there's 4 of us, including one in Brandon, which would be me, and we also have our manager, Tracy, managing our whole process. Anyone that needs to contact the Worker Advisor Office, that is the information, or our phone number, our website, and our email. That's that is the presentation there.
Thank you, Michelle. This is a really great informative session. So once you are talking about, all the WCB claim, and so we got lots of questions from the audience here. I will just put it on the share screen, I think, because I copying on the documents here. So,
Okay.
but however, because of the time wise, we understanding that I already told the folks that because of the time constraint, we're not able to cover all. If you don't mind, probably you may just address couples question here and
Okay.
then take away those and then try to provide the information, and then I will send it back all those information, the answer to the folks once the record session and your your presentation slide is able to share to the audience here too?
Yes.
Awesome, that would be great. So Michelle, can you see the share screen about the questions?
I can. So
Okay.
the number one is, what is the best way to prove injuries that happen over a period of time? So that's when you're going to want to get photos of the workstation. You're going to want to get really, really specific details of the actions of the worker. Like, for instance, if it's, a worker having to skewer frozen chicken, twist it on, you got to really talk about that twist and the force. And always the best way is to try and get doctor support for the fact that it is a repetitive strain injury and that is the predominant cause in the doctor's opinion. That always goes the best. The medical support is usually the best thing that you really need to prove that those injuries happen over a period of time. Other things is if the injured worker knows that other people have been injured, or there have been multiple of this type of injury by other workers doing that same job, that's always good information. Question regarding slide number 3, reporting an injury. When a worker goes forward to report an injury and their employer states they do not belong to WCB, what options does this worker have? Also, in follow-up, what are the basic parameters when an employer has the option not to subscribe to WCB? I always recommend, even if the employer says we do not belong to WCB, put in the claim anyway. You might find out that they actually do, or if they don't, the WCB is going to tell the worker why they're turning down the claim. And sometimes, it gets really down into splitting hairs because some volunteers are actually even covered by WCB coverage. Some employers are from out of province and they actually are still covered by WCB. There's different things. I would always tell a worker, even if the employer states they don't belong to WCB, put the claim in anyway. Does the notice of injury to employer by injured worker or employer report have to use the WCB form, or will you, not me, will they accept an online form by the employer in Manitoba as long as all the details are captured? My understanding is if the employer does not put in a report, then the WCB will actually send the report and contact the employer, because under the WCB Act, the employer, once they find out about an injury, has to fill out a form in some fashion, either a paper form and fax it to WCB, the online form. I believe they have to use the form because there are a lot of specific questions about what the worker's making per hour, what their wages are, that type of thing. I'm not sure whether the WCB would accept not their form, but a lot of times we have seen, pages of extra information connected to the form that was typed in and faxed. Who is responsible for getting witness statements? So there's a good question. The WCB, if they think it's necessary, will contact witnesses. A lot of times the case managers may not contact witnesses, and then in appeal, that is very good information for the worker to actually get. Now, whether or not the employer needs those witness statements or not might depend on, because the employer should simultaneously have some sort of accident investigation ongoing, and in that process may get witness statements for that. but witness statements for the WCB, if the case manager thinks they need them, they will. Sometimes they don't, and that's one of the things that we really struggle with and really do a lot of on appeal. What are we at here for time, Tiffany? Do you want to keep going or?
So maybe just answer one more, then we
Okay.
could wrap up that. Yeah.
Okay, so would an injury that happened on the way to or from work be covered? Well, there's a lot of policies regarding that. So the answer is it depends, because sometimes a worker may be traveling from work and they may take the company vehicle home, and they may be driving with the company vehicle, possibly to, for instance, in my case, sometimes I take a company vehicle and I have to go to the appeal commission in Winnipeg. If I get in that vehicle and then I am injured on the way to the appeal commission, yes, because I am required to travel, somewhere different. If you are getting on the bus the way you normally do every morning, and you're injured on the bus before your shift starts, chances are that's not going to be covered. But again, with WCB claims, every case always has all of these extra details. So that's when you would get into the different traveling premises, those types of policies that are on the WCB websites.
Awesome. Thank you, Michelle. So
Okay.
we got another whole list, from the questions all the folks submitted. So really appreciate your time to share all your knowledge to us. So and thank you, the audience, to really participatory to sending all your comment and questions. So we will try our best to providing you the answer when this is all available, and also with the slide and the record session. So have yourself a great summer. So we don't have any section in July and August. We will see you in September. So bye, everyone. Take care.
Thank you, everyone, for participating, and thank you, Tiffany, for the chance to come and help present some of this information. Thank you.